persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Sit down. There we go. All right, good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I am Judge Cohn, as had been noted. To my right, we've got Judge Monaco. To my left, Judge Jacobus. If anyone has any phones or electronic devices, if you could just either turn them off or put them on silent. We've got 4 cases this morning. The first is a criminal case. Both parties will be entitled to 15 minutes each in their arguments on the criminal case. On the civil cases, each side will be entitled up to 20 minutes. If the appellant would like to reserve some rebuttal time, if you could let me know that in advance, I'll be glad to accommodate you. I wanted to say something just in passing before we begin, and that is that many of you probably are aware that at the end of June, Judge Monaco is retiring.
No.
It's true. It's true. I've tried to convince him otherwise because he's far too young to retire, but I haven't gotten anywhere with that. This is the last oral argument session that I'm going to have with Judge Monaco, and I simply wanted to go on record stating that it's been an absolute pleasure and an honor to have served on this court with Judge Monaco. He's a true gentleman, a scholar, and it really has been a pleasure serving with you on this court.
Thank you. And this is being recorded, right? So I
no, we're not recording that.
Thank you, Jay.
All right. The first case that we've got is SPHALER versus State of Florida.
Thank you, Your Honor. I'll try to make it interesting in light of Judge Monaco's
he's beyond that,
pending retirement.
You know.
May it please the court and counsel.
Well, before, do you wish to reserve any time for?
I probably will. In fact, I'll try to make it as short and clean as possible. It's really pretty simple, this case, and I did want to kind of narrow these facts down as tight as possible because the issue is very narrow and very clean. Basically, we have a 54-year-old man, no prior felonies, 1 prior misdemeanor, driving in his car. He's got a firearm or a handgun in his pocket. Now, the question here is that person a felon, or is that person exercising his Second Amendment right? Now, up to...
There's a statute that says you can't do that, right?
Well, there's a portion of the statute, if the way that the law has evolved in Florida, the relevant portion of the statute is 590.255, which states that if you're going to have a firearm in your vehicle, it must be securely encased or otherwise not readily accessible for immediate use. Right. So the law as it currently stands says that person's a felon.
Right.
And we can put him in prison for 5 years.
So you don't doubt that he violated that law?
No.
What you're contending is that law is
in light of Heller is unconstitutional.
Well, yes, in light of Heller and the recent Stand Your Ground legislation.
Right.
And in fact,
but this wasn't a self-defense. The Stand Your Ground is a self-defense argument. Really, what we're talking about is the Second Amendment.
Well, that's true, except that the Stand Your Ground law is a recent legislative pronouncement on the rights of a person to defend themselves in Florida. And in that, they do not distinguish between home, business, or vehicle, including, and that is a very important point, because what Florida is saying is that if you are in one of those 3 places, you have the right to immediate and deadly self-defense. Immediate is the key question. In fact, counsel...
If I'm a convicted felon and I have a weapon...
I'm sorry, if you...
I'm a convicted felon. In theory, I'm giving you a hypothetical because I haven't actually been convicted yet.
Okay.
So you have a convicted felon and he's in possession of a firearm, and during the course of some event he's required to use that firearm in self-defense. The fact that he might have the right to self-defense, that's a defense to a homicide or aggravated assault or aggravated battery, but that wouldn't preclude him from being convicted of possession of a firearm by a convicted felon. It wouldn't be give him immunity from that.
Well, number one is Heller explicitly states that...
But Heller's a Second Amendment analysis, not a self-defense. I think that, as soon as you try to get into the stand your ground, that you've muddied, the waters, and
Fair enough.
it's not as clear of an issue as what your brief is argued.
Well, it's a supporting issue. It's a supporting point to the larger point in that Heller has clarified the state of Second Amendment law in that it's a personal right, and that means that Mr. Speyer we were talking about his personal right to bear an arm. In fact, it's interesting in Heller when they talk about what does bear arms mean. In the discussion of that on page 10 of the opinion of the court, and that's where Justice Scalia actually quotes Justice Ginsburg to describe what does bear mean. He says, bear means to carry upon the person in the clothing or in a pocket. So when we're talking about a Second Amendment right, that is what he's carrying a firearm in his pocket within his own private vehicle. That explicitly brings in the Second Amendment.
But Heller went to some lengths to say that the Heller case involved a gun in the home. Mm-hmm. And Heller went to some lengths. In fact, the exact quote is, the home is a place, quote, where the need for the defense of self, family, and property is most acute. They specifically outline the home as being a place where Second Amendment rights might be heightened. I don't know how that translates over to a vehicle.
Well, that was a little bit of my argument as to the stand your ground law, and that Florida, we don't distinguish between home, business, or conveyance. Basically, I think the concept here is that if you're in your home...
You want to extend Heller in the event that someone needs to use deadly force to protect themselves. Is that what your argument is?
No, my argument is that if somebody has a right to possess a handgun in their pocket and has immediate access to it in their private vehicle. That is simply what I'm saying.
Do you think the legislature can have any restrictions upon the carrying of a firearm?
Yes, but not in a vehicle.
Okay. What if you're a convicted felon? Can they restrict that?
Yes, absolutely. And in fact, Heller explicitly talks about if you're not otherwise infirmed, and that means mentally deficient. Can they restrict
the concealing of the weapon? That while you might be able to carry a weapon for some purposes, you can't conceal it?
Yes, in circumstances that are not private. I'm saying that in Florida it's pretty clear that you can carry concealed in your home or business based on the case law. The question here is whether this statute, which talks about securely encased when you're in your vehicle, does that infringe on this person's right to bear arms? And in fact, I'd like to bring out something that counsel said in his brief. He says, however, Florida's firearm statutes do not restrict ready access to a concealed firearm. But that's explicitly against what the statute actually says. What the statute actually says is...
You're saying that there's some distinction between secured and ready access?
Yes. Yes, absolutely. It says, if the firearm or other weapon is securely encased or is otherwise not readily accessible for immediate use. So what we're saying is that the restriction that's being placed on somebody in a vehicle is that weapon must be securely encased, and that means otherwise not readily accessible for immediate use. So if something is readily accessible for immediate use, it's banned under this statute. But that's exactly the right that Mr. Speyer has, to access that weapon immediately. And this infringement on his right is what is criminalized and made him a felon. And I'm saying that in light of Heller, that just can't be correct, that 790.255 criminalizes something that he has a right to do. I'll reserve the balance of my time.
All right. We have a little over 8 minutes remaining.
May it please the court, counsel. My name is Douglas Squire, and I represent the appellee, the state of Florida. To start with Heller, page 696, the relief that was actually granted in that case was that the district court must issue him a license to carry the gun in his home. Florida, since 1987, we were the first state to do a shall issue carry law. A nominal fee, and most important, a firearm safety class is all that's required, and you can carry a firearm in your vehicle. And as far as readily accessible for immediate use,
you're talking about the carrying of a concealed firearm.
No, that's permitted as long as it's securely encased. I cite the specific statutes in my brief. I think it's subsection 12. you can carry the gun on your person. And that's the key for immediate use, it says, is carried on the person or as if carried on the person. Snapped in a holster is all you have to do to securely encase it, put it in the console, and stand your ground. It's imminent use. It's not immediate, imminent danger. And in Florida, we require less than Heller. Heller is a discretionary. It's a may issue. Florida, as long as you're not a convicted felon or mental illness or have a history of drug abuse, the guidelines are in the statute that's cited in the brief. You get.
Are there any cases that specifically say that a snap holster is enough to secure the gun?
Yes, I cited in my brief since 1975, even before the new shall carry law.
So if he'd had the gun in a snap holster in his pocket,
yes,
he would not be a felon.
No. It says specifically it cannot be carried. This is all about carry laws, and in Heller, to carry, he was granted the right to get a license because the District of Columbia, it was discretionary, and they had turned him down. And they said the Second Amendment gives you the right to self-defense, and the district laws were it had to be locked or inoperable, rendered inoperable. Our law,
in your home.
Right, in your home.
Right.
Here, in a car, you can have it snapped in a holster, center console. I cite a bunch of cases. There's several out there.
Is what you're saying that he could have gotten a permit? Is that what
Yes,
you're saying?
it's $10 a
He
year.
just didn't have a
I have
permit.
one. I mean, there's nothing to it.
He didn't have a permit.
Correct.
You're not pecking now, are you?
Excuse me? No. And that was one of the first questions the officer asked him was if he had a permit.
No, I'm just kidding.
And for $10, I mean, I paid more to register my car than I pay for 7 years to renew my license.
Yeah.
So if you can afford a car, and this is a vehicle, and as far as the home, business versus vehicle, you've got the element of mobility. That increases the concerns for public safety out on state roads. You simply take a firearm safety class to show that you can competently handle a firearm, and you pay a nominal fee. That's it. There's 700,000 people licensed to carry in Florida. And Heller granted nothing but the issuance of a license.
Well, when you read the language of Heller, it seems, while that was the specific issue in front of the Supreme Court at the time, they're finding certain rights based upon the language of the Second Amendment that go beyond simply the possession of a firearm in a house.
And his name escapes me, but as the majority specifically noted, no carry law has been struck down. There's a distinct difference, and he said the Second Amendment, like the First Amendment, is not unrestricted.
Justice Scalia wrote the opinion.
Scalia, thank you. So if the panel has no further questions, I would ask that you affirm this judgment sentence. Thank you.
He went back to 1789 to find out what was going on at that time. That's kind of what he does.
They have cars back then?
Yeah.
Yeah, and just to be clear, and you made some interesting points. If you have one of these, if he had one of these,
Yeah.
he would have been legal. He would have been no problem.
Is there anyone in this courtroom that doesn't?
Yes. If he's got one of these, look here, this is completely innocent. That is a third-degree felony. I mean, that's what we're talking about. That's the kind of distinction we're talking about. And I'd say that Heller is, I know that it's focused on this D.C. handgun ban, but they use that as an opportunity to explicitly explain the Second Amendment right. And the last page in the holding, when striking it down, they said, the reason that they struck down the D.C. gun ban, the reasoning behind it, the purpose, it's very clear. The prohibition against rendering any lawful firearm in the home operable for purposes of immediate self-defense. So the purpose here, they're saying the purpose of what D.C. was doing was to basically take that firearm, keep it away from somebody so they don't have immediate access. And you have a right to immediate, and the key word is immediate access. Now what...
Well, if you have it in a snap holster, you're not arguing that that's not immediate access.
Well, the state's kind of trying to say, well, we just have a little bit of an infringement. So a little bit of infringement's okay. So how much infringement is okay and how much is enough? I think it's a pretty strong thing. I think the state can't really do anything more than criminalize this behavior. That's about as extreme a sanction as you can over this in a private vehicle. Somebody's driving their car And I mean, and there's no other crime here. This fellow's 54-year-old, no convicted felony, one prior misdemeanor like 20 years before, and now he's a convicted felon because of this little piece of legislation. So I would say that it's the reasoning behind Heller applies to this particular statute. The statute hadn't been updated in 25 years. So the fact is Heller is a very recent decision, and
But one of the, of course, that raises the issue as to whether the venue that you should take this problem to is the legislature.
well, and in fact, I would think that, and I know Your Honors have, it's a big issue here we're talking about, and it applies to a lot of people, though I would say it's a very narrow issue, and what I'm asking the Court is basically this provision of the securely encased provision is the part that we're attacking. We're saying that somebody should have a right to carry a concealed firearm within their pocket, within their vehicle. And the securely encased provision is what makes this criminalized. And that's what I'm saying is unconstitutional in light of Heller. Now, if y'all, legal term, if y'all don't agree with that, I would ask that the question be certified, because I do think it's an upcoming issue. It's a relatively new decision, the Heller decision, and there is a question about whether or not this particular provision stands in light of Heller, and I think it needs to have broader analysis. But I think the analysis is correct. If you look at Heller and you look at the statutory construction, I didn't mention that the specific statutes we're talking about that this legislature wrote said that we want you, the Georgia judges that are interpreting this, to construe this in the light most favorable to the constitutional right to carry and the most favorable to the defendant and the person who's carrying. And here we have a decision, Heller, which is the U.S. Supreme Court, which is saying, in its logic, that he should have this right of personal self-defense and immediate self-defense. And then the legislature says, well, if something comes along, that there's some question here, you should err on the side of this individual, this man, Mr. Speyer, who's doing nothing but driving his car and he's got the handgun in his pocket. You should err on his rights. And I don't think a little bit of infringement is good. A little bit of infringement is infringement.
Thank you.
Thank you very much.
Thank you very much. Interesting.